And we have also notified the other side to that effect, but however, inadvertently, my lord, that is not there in the list.
What is the matter?
My lord, it's a habeas corpus, my lord.
What habeas corpus?
My lord, it's a 3.5 years old kid, my lord.
3.5 years old?
Boy.
Huh.
My lord, the mother sent to the school, my lord, the school was a father. But the school belongs to the father, my lord.
Huh.
My lord, thereafter the child did not return. And the mother went head over heels from one corner to another, could not, the father did not pick up. My lord, even the affidavit, my lord, does not disclose where the child is there. Since then, my lord, since September, my lord, the child is nowhere located. The father says that it is with one distant relative. He had concealed the presence of the child so that the mother
For the other side.
My lord, we have notified them.
Who?
Mr. Dhar is there, my lord.
Which Dhar?
Devoshi Dhar.
Where is he?
And my lord, for the state, my lord, Mominur Rahman.
Where is he? Give a notice, at a supplementary list at 12:30.
12:30. My lord, we shall notify immediately.
And give the notice to the other.
Lord, may I permit to mention, my lord, for non-prosecution of a bail application, my lord. It has not been, my lord, listed.
Hey, এটা নিয়ে supplementary তে এটাও দিয়ে দাও। Non-prosecution করে দিয়ে দাও।
I have 2 matters for non-prosecution. Can I?
Oh, give. Always welcome. Yes.
I'm giving them.
Yes, give. Yes, call the list. List call karo.
My lord,
What name has not gone?
Shagnik Shankar Sikdar will be there instead of Kollol Nag. The rest of the names.
You are for?
State, man.
Sir, this was the slip which was
Yes,
given.
this is our mistake. I apologize. Mistakenly.
Why? Then where is a mistake?
Minor mistakenly.
Why? You're the only three names: Niloy Chakraborty, Saurav Ganguly, and Kollol Nag.
Mistakenly done.
So, who are there? What is the name? Not Kollol Nag. Sonic Sankar Sikdar.
Grateful.
We'll dictate it after this matter. We'll dictate. Don't worry. I am ready with the matter. Don't worry. Yesterday midnight oil I have done.
It has not been ratified by the EC,
We have seen that. You will find my all my notings are there. All my notings are there. Don't worry.
Meeting notes has not been ratified.
No.
Well, I was appearing for the university.
Item number 4, I am praying for an adjournment. The conducting council is the relative of conducting. Lordship,
Why there are two matters? Same party.
Your Lordship, I beg for.
And two advocates.
Lordship, in item number 4, the conducting council closed relative have been expired.
What?
In today morning, the closed relative of the conducting council relative has been expired.
Your Lordship, in item number 3 and item number 4, Your Lordship, I beg to
Not
appear
today.
online.
Not today.
Grateful, Your Lordship.
All sections. So. So the appeal be admitted? Yes. Hey. Admitted? Call for the records, paper book. Section 5 to allow for the section 5 allow for the admission is
For the petitioner, this matter. But I am for the petitioner. Lord,
Who is for the state?
Lord, Mr.
Who is for the state, sir?
Mishra is for. Mishra and Mr. Lokswamy is for this. Lord,
What is the quantity of the contraband?
Lord, contraband not recovered from me.
Not you.
Yes.
Who are you then, sir?
Milord, my name, Milord, I was apprehending that my name transpired from the co-accused statement. On an earlier occasion, your lordship had produced the case diary and your lordship had observed in open court that none of the co-accused had taken my name.
No, we don't go. It's always a comma plus. That may be a preliminary or a prima facie opinion. that is not a
No,
conclusive
Lord,
one.
I was not
So
aware of
don't-
that. But
So
what
don't rely.
No, Lord, I'm not relying on that. Milord, this is the case, Milord. Nothing has been
Because
recovered
we
from.
don't recollect what we have said.
Milord, nothing has been
Yeah.
recovered from.
Purchases, my lord, purchases.
The other
And
purchases.
in 161, my lord, driver of the, my lord, police.
Driver of the
Yes,
police.
my lord, that is the only statement. Because I could not find.
Driver of the police has disclosed their name.
Yes, my lord.
No other witnesses.
No
The
other
driver of the vehicle did not. Then
The accused also did not disclose.
Then? how the driver of the vehicle is aware of his complicity? I driver of means the police vehicle.
Police vehicle.
It was not recovered from the police vehicle. Then
Since he was present at that spot, my lord, he
was
collected that.
that is not there anywhere. Then why you did not arrest him?
My lord,
If he
there-
was present at the spot, why you did not arrest him?
No, no,
Is
my
it
lord.
believable? Then no, he is a driver of the police vehicle. ও কিভাবে জানলো আমি তাই বুঝতে পারছি না। How from where he came to know? Is there any other material which you have unearthed during the investigation against him? Any kind of a call, the call details, any kind of a link which you can establish? Your driver, how he knows? That means he is aware of everything. Why he did not report to you earlier? After all, he is a responsible officer of the police administration. Why he did not? And you have recorded his statement, what he was doing, what he has to do with this.
Was only present at that spot, my lord.
Who was present? Driver of the police
No,
vehicle.
no, raiding party.
Correct. So the raiding party, he was escorting them. And he knows everything. And he did not disclose to his officers that I know these are the persons. Then why you did not take steps? And if he was present at the spot, then why you did
He
not
was not
intercept
present, my
it?
lord. He just heard that they were going to dispose the contraband substance to dispose.
How? Then hearsay evidence is a good piece of evidence. Is this a way the investigation is to be done? Who is the investigating officer?
Right now, what is that? What he has done, he's doing is, my lord, for regarding the antecedents, my lord. He has spoken to the Dinata police station, my lord, and to the IC, and he wants to recollect, he wants to collect the evidence.
When? This incident happened when? November? At least I can see 10/11/2023.
11.
This, then till date, what he is doing? He has not been able to collect. Then what type of a job he is discharging as an investigating? It's a very serious offense. Very serious offense. At one time you say he was present at the spot, at the time then he was not present at the stop. Second time you say the driver of the raiding, the
they were
team
not-
hard.
My lord, there were five accused, my lord, five accused named in the FIR, my lord.
So
Three of them have been arrested, my lord, but from the confessional statement, my lord, their names have not been recorded.
Then-
Present petitioners, my lord.
then there must be something to rob him or to put him into this. I can understand and appreciate if one small piece of the evidence against him, I can very well understand. None of the co-accused has disclosed that he has any involvement. Till date, you have not been able to collect a single piece of document about his antecedent that he is the habitual offender.
Charges is pending, my lord, please.
Maybe the case has been launched. The above mentioned case has been launched, has been lost, having intercepted the vehicle and recovered the contraband above the commercial quantity. Full stop. 3 persons were arrested and it is the case, it is a case of the prosecution that 2 of them have absconded.
2 of them.
The petitioner was neither at the spot nor any recovery is made from his possession. The prosecution says that the petitioner is a intending purchaser, which has been diversed by the driver of the vehicle carrying the raiding team. Interestingly, the statement of the driver of the police vehicle is recorded under section 161 of the CRPC, which also could not disclose any direct complicity to the commission of an offense so far as the petitioner is concerned. Even a driver could not say with certainty that the petitioner is involved in the racket. What he discloses that he over here that the aforesaid goods would be sold to the petitioner. None of the accused who have been arrested disclose the name of the petitioner. In this regard, in such view of the matter, and in absence of any incriminating materials against the petitioner, we do not find any element which would deny the protection against the arrest. The exceptions carved out, CARVED, carved out in section 37 of the NDPS Act appears to have been fulfilled, and therefore we do not find any justification in denying the benefit of pre-arrest. Accordingly, 10,000 in the satisfaction of
For the arresting officer, my lord, since charge sheet has not been served.
arresting officer, and one must be local. Other conditions are 438(2). Further condition that he will meet the investigating officer once in a week. And or as and when required by the investigating officer, both
Lord.
and
My lord.
and shall not अच्छा.
Grateful, my lord. Grateful.
Present petitioner.
But I'm for the petitioner, my lord. My lord, presuming a preparation of dacoity, my lord, the police suo motu registered
Arms Act.
arms act, my lord. My lord, registered, my lord, a case, and my lord, 3 persons have been arrested, few article has been, my lord, seized. Now, my lord, from their, my lord, confession, from the confession of those persons, 3 persons who have been arrested by the police, my lord, they extracted a few names from where this particular petitioner's name has been, my lord, revealed. Now, my lord, by virtue of section 25 of the Evidence Act, my lord, any confessional statement, my lord, extracted during the police custody, my lord, is inadmissible in evidence. So, my lord, nothing has been seized from my.
For all intent purposes.
My lord, on the basis of
27 is an exception.
My lord, 27, my lord, leading to discovery. 25,
That is what I say. Is you say that it is inadmissible for all intent purposes. I ask.
But
there is an exception.
My lord, their name has already been, my lord, extracted, my lord. And my lord,
extracted.
My lord, they stated, my lord, during the confessional statement by the police. My lord, few other accused persons have been enlarged on bail by the coordinate bench of this honorable court.
Including the arrested person.
No, my lord, they have been enlarged on, my lord, anticipatory bail. My lord, kindly have a look.
The cases, Lordship,
Are whether he stands on a same footing with that of those persons. I am simply. This is whether he stands on the same footing of Mukshedul Mia. Or yes, Mukshedul Mia and Utakuntak. Why 2 orders of Mukshedul Mia and others? I do not know who are others. This is a very clumsy way of relying on that
statement of the arrested accused person.
All those
No, whether he stands on a.
Lordship, Moksadul's name has been revealed by another arrested accused person.
Whatever. One arrested, another arrested, they stand on a same footing. Whether the same allegations have been made against him.
The case is that the police got the information. So I have not this petition.
হনিরুল মেট্রো এ হচ্ছে হসিনুল মিয়া।
হ্যাঁ, মাটি।
না, না, এটা হচ্ছে তো মনিরুল মিয়া, আলী হোসেন, তারপর খন্দকার, তোলে, হাসিনুল মিয়া, লেবু, আসাদুল, ইলহামের আরো অনেক। তাদের নাম
Page 35, 36, other two statements.
না না, এটা হাসিনুল একটা হলো, মিথুন মিয়া নিয়ে মেয়েদের দেখতে পাচ্ছি না। মুজিবুর রহমান আছে এখানে। মিঠুন নাম মনিরুল নেই। তারপর আবু বক্কর মিয়া, বক্কর, মুসলিম বক্কর কিছু আছে নেই। তারপর জাহানুর মিয়া, জাহানুর আছে, আচ্ছা ঠিক আছে।
There are two more statements,
So-
35 and 36.
পেজ
35 and 30, this is 37, Lordship, 36 and 35. Three accused persons were arrested and there are three statements.
পাটোয়ারি নেই। তারপর মনিরুল মিয়া, মনিরুল নেই। আলী হোসেন, হ্যাঁ আলী হোসেন নেই। তারপর আলী খন্দকার সোলে, জাহানুর নেই। বক্কর, হ্যাঁ এখানে পাচ্ছি। আবু বক্কর মানে বক্কর, এটা পাচ্ছি। ঠিক আছে। তারপর আমিদুল এখানে নেই। তারপর মফিজুল নেই। আরো অনেক, এটা ভাবনা মুজিবুর আছে, মুজিবুর রহমান তো, মুজিবুর রহমান।
Another statement is 35.
এখানে পাটোয়ারি, মনিরুল তো এসে গেছে। তারপর আলী হোসেন, মকসেদুল নেই। These are the only three statements.
Three accused persons have been arrested and they made three statements.
So at least the petitioner number two's name has not been, nowhere.
By the arrested.
They have not disclosed, and they only one person disclosed number one,
Number one,
and the 2% disclosed
3 and 4.
3 and 4. So কিন্তু ওরা ওখানে ছিল,
This was their side business, Lordship. This was their side business. The fundraising for cattle smuggling. So the dacoity.
No.
So it has
That-
been mentioned, Lordship.
No.
Then the main business is cattle smuggling.
No,
Cattle smuggling. For raising the fund, they have engaged into these dacoities and other things. It is mentioned, Lordship.
we'll grant a bail, anticipatory bail for 2. No. Not.
But all are standing on the same.
No footing. At least there is no name disclosed of the 2.
My lord, it is all about, my lord, their confession, my lord.
The 3 persons were arrested in connection with the aforementioned case. And their statement has been recorded under section 161 of the CRPC. We are conscious of the proposition of law that the statement of a co-accused before the police authorities may not be a reliable piece of evidence, but we cannot overlook the complicity of the petitioners or their role in relation to the same for the purpose of considering an application for anticipatory. We have seen the statements recorded by the investigating officers, and the investigation is still at the nebulous stage. It is revealed that so far as the petitioner number 1, 3, and 4 are concerned, they have ganged up as their business of cattle smuggling could not yield. Could not become remunerative because of the high amount of an expenditures to be incurred in this regard. So, in such view of the matter, we do not think that it is a fit case where the petitioner number 1, 3, and 4 should be granted bail. Should be extended the benefit of pre-arrest. Accordingly, the prayer for anticipatory bail is rejected, so far as 1, 3, and 4 are concerned. We do not find from the statement of any of the co-accused on the involvement of the petitioner number 2. His name is neither disclosed, nor the investigating officer at this stage have been able to gather any evidence against him. So, in such view of the matter, we are inclined to grant an anticipatory bail to the petitioner number 2. So, in the event of an arrest, 10,000, 438(2), and meet the investigating officer as and when required, as and when called.
Out of 4, my lord, 3 have been rejected. Out of 4, 3 have been rejected. My lord, all are standing on the same footing, my lord.
No, sir, definitely not.
But their name has been
Definitely not.
transferred.
Sir,
Professional statement,
sir, cattle smuggling
But that is their allegation, my lord.
Let us see, let them and expedite the
But
investigation.
I presume to be innocent.
Expedite the, yes, expedite.
I'm appearing for the petition. The FIR has been drawn under section 436 and 34 of the Indian Penal.
Lordship, may I permit, Lordship? So I am for the state, Lordship, in this, Lordship, this petition is not maintainable, Lordship, as per charge sheet submitted on bailable. Yes, Lordship, bailable.
There is one difficulty, my lord.
What difficulty?
Kindly come to page 10. That is there, my lord, what learned counsel
What,
for the
sir?
state. Kindly come to page 10, my lord. Well, for once, kindly come to page 10.
Yes.
The
But-
difficulty lies in the ambiguity, because in the first page, they are saying charge sheet number 193, third line, charge sheet number 193 of 21 dated 15 September 2021
Correct,
under section 436, 34 of the IPC.
correct.
This is a non-bailable offense. However, my lord, kindly come to page 13. Second para, first line. They have rectified it. First, they have typed 436.
Wait, have patience.
Mal.
Have patience.
Mine.
Which line you are referring?
Page 13 of page 13.
Page 13.
Second para, first line.
Accordingly, I am submitting the charge sheet.
Yes. 436 has been corrected by hand and
What is this?
435. Because actually 435 is attracted, which is a bailable offense.
So better.
But
that
yes,
goes
my
in
lord,
your favor.
but the ambiguity is, my lord, in the first
What
page.
is
they
an
have-
ambiguity? Now initially the FIR may be registered under a particular section. But during the investigation, if no ingredients of that section is found,
Yes.
and then the ingredients of another section is found,
Yes.
there is no difficulty on the part of the
Yes.
IO to register,
Yes.
to
Had it been-
file a charge sheet
Yes.
under that. And these are all billable in nature.
yes.
So there is
Yes.
where is a difficulty?
Had it been, my lord, in the FIR, then there was no
There's
problem.
no-
But kindly come to the first page of the charge sheet, that is page 10.
Mhm.
In page 10, they have mistakenly.
It's not a mistakenly, sir, when they come, please, let me understand this branch of law. When the complaint or something is registered, and if the investigating officer or the police or authority found that there is some kind of an element or ingredients of this particular section, then he is bound to record an FIR under that section. But during the investigation, if he found that no,
Yes.
he has not been able to prove there is nothing so far as this section is concerned, he is not obliged to
Yes, ma'am.
file a charge sheet under that section. He is not.
Yes.
So what he has done is that he has given a lesser
Yes.
provision, and then you should be actually complimenting him that you have. So why anticipate?
Man, kindly record them, man. Kindly
What record? Nothing.
man,
You have,
435 is,
sir,
charge sheet
you
has been
have,
submitted in
you have,
435.
you have submitted, you have annexed that application, the charge sheet. You knowing fully well. You wanted just a rubber seal of the court.
Man, because, my lord, in the
You
charge sheet
wanted
itself-
the court to be instrumental of recording this fact.
Man, because, my lord, in the charge sheet itself, my lord, in two places, two sections have been entered.
No, has to be, because the opening sentence that under what section the FIR was lost, he
No,
has
my
to
lord, this is the
disclose.
charge sheet.
He has to disclose that under what section first the FIR was lost, and then what transpires in the investigation, and ultimately he has said, no, this is not a section. This is a correct section. Obviously, he will do it.
Oh, bless.
You wanted a rubber seal.
Oh,
35 is a billable document. Mischief by fire or explosive substance with the intent to destroy house. When house now van hote. I have seen that. The instant application for anticipatory bail is taken out for the reason that the FIR was lodged under section 436/34 of the Indian Penal Code. So since the punishment under section 436 is of such nature which is non-billable, the present application is taken out. Will you withdraw or we will record?
My lord, kindly record, my lord, there is an ambiguity, my lord.
There is no ambiguity. But recording that. Interestingly, a copy of the charge sheet submitted by the investigating officer before the jurisdictional court is also annexed with the instant application, despite the fact that the investigating officer does not find any ingredients of section 436. And in fact, the charge sheet has the charge sheet, the ingredients of section 435/34 of the Indian Penal Code was found. The counsel for the state also submits that the charging section in the charge sheet is a bailable offense, and therefore the application for anticipatory bail is not maintainable. So, in such view of the matter, the application is dismissed as not maintainable.
Deeply.
Bengal accept that. Allegation is that, my lord, that.
What you have done with the foreign liquor?
My lord,
You have imported certain foreign liquors, but you did not pay any excise.
no, it is not that.
Then
The allegation is that in a godown, some non-duty paid foreign liquor was found. And the petitioner is a owner of a restaurant in the vicinity of that day.
vicinity
Yes. just
from
opposite.
your compound, it is not found.
No.
What are you
They have
saying?
nothing to do with that godown. There are several bars are there, at least 7
Then
bars
this
are
go
there on
down, this go down belong to whom?
to the city center mall, Ambuja Private Limited.
No. They are not using it. They must have leased out. They must have given on rent to somebody else. Who was found?
No, my
You
lord.
don't know.
No, I know.
Let us have that documents
Yes,
from
yes,
him.
my lord. They have nothing to, they have not leased out to them. They have, it is
Whatever,
not
let us
rented to
see.
them.
Let us see what
The city center mall itself is the owner of that.
let us see.
Serving it through their.
My lord,
Yes.
there was a record, there was a letter in the record. I don't know. I think they are referring
the city center mall authority themselves shifting their buck and written to the police station that it has been, but they cannot show any
Charge
document.
sheet has been filed.
No, Lordship,
No, no.
investigation is going on. We need them for custody later.
My lord, the thing is that another important thing, the excise department, it is for only, main thing is for payment of the duty. They have served them.
This is not a very small thing, as you said, very minuscule
No,
offense. No, it's a serious offense.
This is a
My
law.
lord, my lord, but-
in both
but-
ways.
but-
Either
But the thing is that they don't have anything to do with that godown.
loss to government
It has-
exchequer as well as to public
Don't
health,
worry.
Lordship.
My lord,
They were catering
They
to
have
their
got nothing to do with the go down.
my lord,
Don't worry.
my lord. There are several bars in that floor. There are at least 5 bars on that floor. And that was not also, godown was not also locked. It was open godown. My lord.
Very innocent.
My lord, the thing is that they have also served a notice to meet the collector on the 27th. Now in that,
Did you meet?
how can I be arrested?
Correct. You arrested, so let
So my
you
lord,
be arrested, then
So,
we'll consider.
my lord, the thing is that just,
You will
can
be
they,
arrested then.
can they show
If,
any?
sir, I do, it's a very, the irony of your argument is very interesting. If you are absolutely a genuine and honest person,
My
that
lord,
you have
my-
not done anything what you are saying,
My lord,
where is a sense of fear that you will be arrested?
the thing is that,
Thing is that the thing is different.
warrant in the court.
Obviously. Let them.
So can they show any document that this godown
We will-
belong to them? No document is there. They cannot show any
We
lease.
can't
agreement or
disclose
nothing.
at this stage, but there is.
What they are relying on, I don't have a copy, sir.
You will
my
not.
lord,
You will not. It
These
is
are
still at
privileged
the,
documents now.
you will not. I think some other state, they are entitled to a copy.
my lord,
But so far as the West Bengal, no amendment has been brought in this.
Well.
This is an application, it is submitted by the council for the petitioner that he has been unnecessarily chased by the police authorities in connection with the aforementioned offense when he has got no relation or connection with the unit from which the foreign liquor, non-duty paid foreign liquor were seized. It is further submitted that a notice was issued under section.
they have not given any, just simple notice, statutory notice to.
Give us. A notice was issued.
My lord, may I?
From the superintendent of excise on 12/2/2024, directing him to appear before the collector of excise Darjeeling on 27/2/2024 at 12:30 p.m. to offer an explanation regarding the aforesaid offense, which would impliedly prove that that the petitioner's involvement is still uncertain. Next slide. The state opposes the prayer for bail. It is submitted that the incriminating document, the materials have been gathered during the period of investigation. which cannot rule out the complicity of the petitioner in committing such offence. It is further submitted that the investigation is still at the nebulous stage and the custodial interrogation of the petitioner is necessary. So upon considering the submissions and the materials seen from the case, the stand of the petitioner does not appear to be the complicity of the petitioner cannot be ruled out at this stage. Further, the investigation is at the nebulous stage, for which we feel that the petitioner is not entitled to a privilege of a pre-arrest. Petitioners. Pre-arrest. Furthermore, once the notice has also been given, if the petitioner is trustworthy and stand on the facts disclosed in the instant application, there was no occasion on his part not to appear before the said authority. Admittedly, the petitioner did not comply the requisition made in the said notice, and therefore we are not inclined to grant such benefit. Accordingly, the prayer for anticipatory bail is rejected. Look at what India's inspection. Lordship. Beginning, the first line, the expression police authorities may be referred to excise also. No, he will achieve first line.
Notice.
Follow the excise authority.
আচ্ছা ঠিক আছে
Yes.
Item number 10, I am going to know.
Why, madam?
Out of session.
But this matter was mentioned for being taken up today. Yes. No. Why you mentioned the matter then? Hey, কালকে কি mention করেছিলেন এই ম্যাটারটা? No. Not today.
Item number 11.
What?
Out of session.
In advocate and record was Mr. Joydeep Kanto Bhaumik. Here is a Sayantan Bhaumik both. So both the Bhaumiks have gone. Yes.
But in this matter, I am only praying for expeditious of trial. Earlier, this application was rejected, and 20C, I am in custody about
What is the stage of a trial, sir? Sir, what is the stage of trial?
Mr. Saurabh Ganguly is there.
What's going on?
Password 5 minutes. 5 minutes.
Where is the PP? Additional PP.
Station this son's exam started.
Passover, come.
Yes. Or item number 13 or 14, my lord, I bring for my lord, and not placing this application. 13 or 14.
Yes. Do you have anything to say?
Commercial quantity, my lord.
Not pressing.
Not placing.
The counsel for the petitioner submits on instruction, that his client is not intent to proceed with the instant application and prays for dismissal thereof. In such view of the matter, the application for bail is rejected as not pressed. Same order in
14.
14 as well.
Madam, for the petitioner. The prosecution case, my lord, claims its origin, my lord, from the
First,
post-war
there are
violence.
many matters. Let us see. What is your name, sir? I mean, Subhas Burman.
Subhash Babu.
Subhas Burman.
But
In connection with the same case, many applications for bail has been
Yes, ma'am.
filed. Some are pending and some have been disposed of. এই নামটা তো আগে দেখেছিলাম না, মিথুন মিয়া।
And lordship, if I am permitted, my lord, petitioners, my lord, the petitioner's bail prayer before the court below has been turned down twice.
but does it disentitle me to file an
Yes,
application?
yes, sir.
My lord, kindly come to page 16 of my application, my lord. 16.
What is this?
Page 16. My lord, this is the continuation of the, my lord, investigation report by the CBI, my lord. My lord, the last paragraph, my lord, kindly have a look, my lord. My lord, may I read it out, my lord?
Just, I am a fast reader than you.
Lots.
So last paragraph, what do you want to say? It
Lord-
simply says that everybody belong to these scheduled tribe community.
No, my lord.
That is at page 6.
My lord, the last paragraph starts.
Sorry,
with
there are
Govindu
two
Varma.
numbers.
Govindu Varma.
Sorry.
Govindu
Two
Varma.
numbers. Sorry. Yes, then
My lord, clearly reflects that, my lord, the Hakim Mia, my lord, was the, my lord, principal assailant.
yes.
My lord, who, my lord, orchestrated the entire crime. He hurled bomb, he assaulted the deceased victim. And my lord, very surprisingly, my lord, the last line, that Anando Bormon uttered Ma and fell on the ground.
Correct.
My lord, I wonder that an incident which took place more than, my lord, 4 months back, and the Central Bureau of Investigation, my lord, took the investigation after 4 months. And my lord, they came to know that what uttered by the deceased victim before his last breath. My lord, it, my lord, presupposes the firm presumption, my lord, that the entire investigation, my lord, is a, my lord,
already, he says only IO is to be done.
My lord, I and maybe one or two Caesar witness. Caesar witness.
We will say that whatever the rest of the witnesses are,
Lordship,
they will examine on that particular next schedule of witnesses. which
Lordship.
are there.
Lordship,
And you will also cooperate in cross-examining those.
my lordship,
That's all. So that at least the trial comes to an end and then the judgment. will be
Lordship,
there.
lordship.
The petitioner has filed this application for the alleging that there is no entry of found against the in relation to a commission of an offence for which the present case has been lost. The council appearing, sorry, the deputy solicitor general of India appearing for the CBI service, that the evidence is virtually complete. Barring the evidence of the Caesar witnesses as well as the investigating officer. And there is every possibility of bringing the case to its logical end at an early. Since the entire trial has been conducted while the petitioner is in custody. At such back end of the trial, we do not feel that it is a good case where the petitioner will be allowed for bail. However, we make it clear that the CBI will produce the left out witnesses on the next schedule for recording evidence fixed by the CBI court, special court, CBI. And complete the examination in chief. It is further made clear that the petitioner cannot speak any adjournment. 1997. But to cross-examine the opposite witnesses so that the matter can be brought to its logical, so that the allegation can be brought to its logical conclusion. At an office. The application was made with these observations, the application was that to happen. We need that, we need.
Lordship, we have downloaded it, we get it.
Yes.
Lordship, item number 18, I'm paying for market. Item number 19 also.
119.
Commercial quantity. Lordship, item number 20, I'm praying for next circuit. Kindly not today, Lordship.
Why?
Lordship, the advocate on record. Another.
It was here yesterday.
No, not my singer's matter, Lordship. It's another advocate's matter, Lordship.
No, it is another.
Hindul Shah, Lordship.
No, where is he?
Lordship.
He was here.
Lordship, then make a passover.
Passover. Let him talk.
Three matters, Lordship. 20, 21 and 22.
21.
Kindly pass.
Call him. 22.
Lordship, three matters. 20, 21, 22.
Yes, next.
20.
My lord, NDPS Act. There was an order from this,
What is not MDPS Act?
my lord, the case is under NDPS.
21C, right? 25 also arms act.
Yes, my lord. My lord, there was a specific direction from this honorable court to conclude the trial.
As expeditiously as indicated in the order of 1st of December.
Yes. Now within 9 months, that was clearly stated. That was over in September,
I'm talking about page 8.
page 8.
Page 9 is as expeditiously.
No, not,
Agreement of 1st December 2020.
My lord, already
I have annexed the order of dated
10
1st
witnesses have
December.
been examined.
That is page number 17, my lord. Page number 17.
Another 2 left, my lord. There are 14. Out of them, 10 has been examined.
Who are left?
The IOs.
And?
And one recording officer, it's not compulsory.
Judicial magistrate, and then another independent witness. 2 independent witness, one has been examined, other has not been produced, and one I have annexed the copy of the independent witness. Just my lord, kindly.
Sir, if you do not find there is any material which may lead to your, then you can make an application for your discharge and acquittal.
No,
Under
that-
the CRPC, you can make, I think 232 is the provision.
My lord.
You can make an application.
My lord,
for
the
acquittal.
thing is that there was an order to conclude the trial by September, but on the last 6 dates, no witness has been turned
Why
up.
you did
On
not
last
produce
6
the
dates,
statement? Why you did not produce?
I have annexed all the order sheets.
Where is the investigating officer?
And September, October, November, December, January, February, 5 months have elapsed. On last 6 days, no witness was present, my lord. And if my lord,
Why you are not producing the witness?
We are
I
trying.
know you could have, he was always there in the court.
My lord.
Suppose if the other independent witness is not coming, at least the IO may be examined, at least case is progress.
Well, the next date is on 15th of March 2024. We'll finish up.
that will go on.
It is fixed on 15th of March 2020.
Only 15th or?
Only,
something?
only.
Then
1 day left, we'll complete it, my lord, without fail.
all these 4 witnesses?
My lord,
Yes,
my lord,
we are recording your estimate.
my lord.
My lord, one more thing. My lord, if my lord kindly come to page 23 once. my lord. There were, page 23.
Yes.
There were 2 independent witnesses. They have not examined one has been examined. He is clearly stated, I signed in a blank page at police station. I was not present on the place of occurrence.
It's a subject matter of trial, my lord. He will get the benefit of that case.
He is stating that I was not present in a blank sheet. I don't know what is
Whatever
written
it is,
there.
it has to be-
At the
it has to
later
be-
stage, it was
It
taken.
has to be supported by the other evidences also.
If after taking the evidence of a prosecution, examining the accused and hearing the prosecution and defense on the part, the judge considers that there is no evidence that the accused committed the offense, the judge shall record an order of acquittal.
My lord,
If
that-
there is nothing, you can apply under section 232 for your acquittal. Why the court at
No,
this stage
but
is
the-
going to this aspect?
My lord, but what
So,
about the,
although we don't have a privilege of looking at the evidence, we don't have a privilege of what has been done, and you are arguing this matter before.
that I
me.
understand. But
Yeah.
what about the specific direction to conclude the
We are-
trial?
we are just
5 months have elapsed,
we
my
are-
lord.
We are taking care of that, sir.
My lord.
Come. The instant application for bail is founded upon the assertion that despite the specific directions passed by this court to conclude the trial, there has been a considerable delay. It is undeniable that the petitioner is languishing in jail and the trial is conducted. The trial commences. As the application for bail filed by the petitioner was rejected. It appears that out of 14 witnesses, 10 witnesses have been examined. It is alleged by the counsel for the petitioner that since last 6 officers, the prosecution has not produced any witness. And the time limit which was set forth in an earlier order has been completely shattered. We also find that there was a specific direction that the trial should be completed within a time limit indicated there. But equally, we cannot ignore that the 10 witnesses have already been examined. It is submitted that the next date is fixed on
15th of March.
March 2024 for evidence of the other witnesses. The counsel for the prosecution submits that those witnesses shall be produced on the same day. And no adjournment shall be sought on behalf of the prosecution. In such view of the matter, we do not think that once the trial has progressed substantially and virtually at the back end of and reached to its fag end, and virtually reached to its fag end. It is the prayer for petitioner for bail, the prayer of the petitioner for bail cannot be considered and thus rejected. However, we make it clear that the prosecution would produce the witness on the same day. And the counsel for the petitioner also assured that in the event the examination in chief is recorded, they would cross-examine such witness. For any reason beyond the for any reason beyond the conceivable imagination, all the witnesses could not be examined on the same day. The special the learned judge special court shall ensure that the evidence is complete within fortnight therefrom, and shall refuse all unnecessary adjournments to either party.
Grateful.
Grateful.
For 24.
Lordship, I am for the petitioner's lordship. The NDPS case, lordship, is a renewal of bail application, lordship.
You are Papi Singho and another. Who is
Another. Yes, lordship.
So 1, 2, 3, 3 applications rejected.
Lordship, they are not pressed, lordship, 3 application and lordship. The last order, lordship. Annexure 13, lordship, 23rd 11, lordship. But till today, lordship, not a single witness was examined, lordship. And lordship,
What is happening nowadays?
2 years, 5 months already lapsed, lordship, not a single witness.
Why?
Earlier, bailable warrant issued till to the lordship.
29th of February has been fixed for evidence. This one.
How many witnesses?
Followed 12 witnesses.
So how many witnesses you will produce on that?
Lordship, may I argue on a law point, lordship?
Are you on a law?
Yes, lordship. Lordship, in this case, lordship,
That
this,
has to be ascertained, madam.
lordship,
How many witness has been fixed for 29?
lordship, 265 gram brown sugar and 22 bottle of coated mixture seized from the possession of these 2 petitioner on 21st September 2021. Lordship, in this case, inventory was made, done, certificate for inventory on 8 October. Prior to that, lordship, the coated mixture already sent to the FSL. And thereafter, the brown sugar was sent to the another laboratory This is the lordship two report, lordship. So both the reports says what? Lordship, first report, that is the coat and mixtures that is done before inventory, lordship. Lordship, as per lordship, the rules, narcotic drugs and psychotropic substance act, seizure, storage, sample and disposal rules 22, lordship. Has it been put in place after this Mohanlal's judgment? 22 rules, lordship. This is lordship, kindly please, lordship. To copy it. Rule starts. Yes, what it says. Lordship, as per rule, lordship. Lordship, the sample must be done in presence of magistrate, and thereafter that should be sent to the. That is the 52A. Yes, lordship. Non-compliance, lordship. And lordship, another part, lordship, that the 265 grams of brown sugar seized from the possession of. What is the commercial part? 250 grams. And lordship, inventory, there is when the alamat produced before the magistrate is 190 grams. Lordship. The total quantity of brown sugar is produced at the time of inventory, lordship, 190 grams. So below 37 is not attractive, lordship. 2 years, 5 months and the bar, lordship. So he's saying that there is a variance, 265 and 190.
Lordship, there is a contradiction. So, well, that will be, my lord, at the course of trial, my lord. It
It is
will.
a Bombay judgment. Justice Chavan's judgment.
On all these aspects.
In your favor, why you are not bringing? You only attract the commercial quantity, lordship.
But all these aspects will come out from the depositions.
That is what the Bombay High Court has said, no. The difficulty is, I tell you very well, when it comes within the intermediate quantity.
Lordship.
Then the rigor of 37 will not come into play. Then what to do? Tell us. You said 265, that is above the
Commercial quantity.
Now it appears 190, which is below the commercial quantity. Whom to be believed? What to be believed? Where it has gone? The rest, 75 gram, where it has gone?
Lord, that, my lord, contradiction, my lord, the correction report has been, my lord, corrected
No,
by the
that's
magistrate.
That's why this disposal rules was enacted. It is for that purpose where 75 gone.
But that will come out from the deposition of the, my lord,
Deposition, that will come out from the investigation of the IO itself
lordship.
or the reading team. Who is the highest authority in this regard? We are directing him to immediately initiate the proceedings and then find out what is this. Who is the highest
My lord,
authority?
IG, my lord. IG.
IG any?
Can IG is not?
ADG.
Additional Director General.
Oh, ADG not possible, আছে?
ADJ not.
DG not.
Director General not.
IG nahi.
So why not the case to be initiated against him?
My lord, all this, my lord, clarification, my lord, will come out from the deposition at the
What
time of.
deposition? What are you talking about deposition? The magistrate, can you, this is more sacrosanct.
Lordship.
We
Yes.
don't believe what your authority says. But we can't disbelieve what our judicial officer or the
Yes, yes.
magistrate says.
Lordship.
The magistrate has indicated 190, which is much below the commercial quantity.
Lordship.
Then who is to be believed at this stage? And then the question, very burning question, where 75 grams
Has gone.
gone? Where it has gone? Oh, this is something which is apparently, I mean, this is intermediate. Intermediate. And what is the total 2 bottles of contraband? Syrup, what is that? 2 bottles?
22 bottles. My lord.
Lordship, after inventory, the hotel mixture not sent to the FSL, Lordship.
Let us see. One contains a brown sugar,
Yes,
which is an intermediate quantity.
Yes,
Now,
Lordship.
from yours.
yes,
But you also have been found to possess another content.
yes, Lordship.
Let us see whether that is above the commercial quantity. Let us see.
My lord,
What is this?
page 54, my lord.
How many bottles this is?
My lord, 2 bottles have been sent.
2 bottles.
This is what is there?
10 bottles.
ML?
10 bottles, Lordship. 10 bottles of coated mixture come under purview of
Commercial quantity.
Of
100 ml, 100
Or the
ml.
bottle. The bottle may be of 5 liter.
Lordship, all the
100
bottles,
ml.
100
Each bottle
ml.
contains, my lord, 100 ml.
So you say that
10 bottle, that means 100 ml to 10, 1000 ml.
means one liter.
Yes.
1 liter is a commercial quantity.
Commercial.
And 2 bottle, how many? 100 ml or what?
My lord, 20 ml, milliliter, my lord, have been sent.
So 20 ml. So it's only 40 ml.
No, my lord.
Enter 200 ml.
That is what I'm saying, that each bottle contains how many?
100 ml.
100 ml.
So that's it, then 200 ml,
200 ml.
which is much, even not an intermediate quantity, which is much below.
But my lord, total bottles seized, my lord, 22 bottles.
Produce before the
You
magistrate.
say 2 bottles is,
Produce before the
you
magistrate.
produce before the magistrate 2 bottles. Where then 20 bottles gone?
So that is, my
Do
lord,
we believe the rat story?
there is a contradiction.
No, no, only 2 bottles, 2 bottles. Twenty-two bottles also. Going on. Why you did not mention before us on the first day? Why you did not take that plea earlier when your application were rejected?
Lordship, at that time, Lordship, I am not the conducting advocate, Lordship.
So the better brain came for the first time.
Yes.
You appeared on 23rd of November.
No, Lordship, Anirban Banerjee. Lordship. 25.
Where is the Caesar list?
My lord, Caesar is on page 8, my lord.
Several applications filed for bail by the petitioner. Two rejected by this court. Last of such rejection was on 23rd November 2023 in CRN NDPS of 2023. The instant application for bail is taken out on the ground that there is a significant variance in the weights of the contraband. Between the Caesar list and the certificate and the certificate issued by the judicial magistrate while exercising powers under section 52 capital A of the NDPS Act. It is thus submitted that because of such variance, and if the certificate issued by the judicial magistrate is taken to be sacrosanct, the quantity allegedly recovered from the joint possession of the petitioner is below the commercial quantity. The Caesar list would reveal that 265 grams of brown sugar together with 22 bottles of Cofrex, C-O-F-R-E-X, Cofrex cup syrup, each containing 100 ml, were seized at the time of interception. So far, sorry. However, the certificate issued by the judicial magistrate, the first court of judicial magistrate Siliguri, where the entire alamat was produced, indicates 190 grams of brown sugar and 2 bottles of the said cough syrup containing 100 ml each. There is a stark difference in the total weight and the number of bottles. If the certificate issued by the judicial officer is taken to be sacrosanct, which ought to be, the quantity so revealed is below the commercial quantity. On the other hand, if the season list is believed, the contraband so recovered is above the commercial quantity. The counsel for the state is unable to disclose such alarming difference in the total weights in absence of any instruction from the investigating officer. Considering the aforesaid facts, which are serious in nature, and bearing in mind the provisions contained under section 52 capital A of the said Act, where the entire seized contraband should be produced before the magistrate, we feel that an independent investigation is required to be made, and the person found responsible therefore should be dealt with the iron hand. We therefore direct the additional district, what is the additional director?
Director General,
Additional Director General, Jalpaiguri,
North Bengal.
North Bengal.
sorry, North Bengal, to personally look into the matter and submit the report to this court within 10 days therefrom. It is open to the said official to take an appropriate steps against the person found responsible for such discrepancies and or serious lapses, so that the recurrence is completely stopped. Bearing in mind that the earlier applications were dismissed by the court, believing the statement of believing the total weights recovered as disclosed in the seizure list to be above the commercial quantity, we do not intend to pass an order at this stage for release of the prisoner on bail. However, after the filing of the said report, the prayer for bail shall be considered. Lift the matter after 10 days.
Dip to.
My lord, one indulgence, my lord, let this order be, my lord, communicated to the.
You communicated, you are representing the. That's all the next 25.
But I am for the petition. But offense under section 420, 417, 34 of the Indian Penal Code. But kindly see page number 10. Yes, my lord. But kindly see page number 10 of my application. This is a complaint. But this attempt to, my lord, cheat was not committed, my lord. Only attemption, my lord, attempt.
Why
And-
you attempted?
But that is the allegation, my lord.
Yes.
I am an innocent person. Kindly see the page 10 of my application, this complaint. They went to the, my lord, shop of the informant, asked money for her mother's treatment. 58 days in custody, my lord.
The case has been initiated against the petitioner on an allegation that the petitioner attempted to sell the spurious gold on the pretext of an urgent need of money for the treatment of her mother. The complainant has also revealed, has stated in the complaint that before he could part money, he get that particular article examined from the experienced jeweler to opine that the gold is spurious. The fact remains that though an attempt was made, but the complainant did not suffer any monetary loss, nor we thus do not find that any custodial intervention is required in connection with the aforementioned case. Accordingly, the event of arrest.
But this bail application.
Oh, bail.
Yes, 58 days in custody.
What is the stage of the?
Charge sheet not filed, my lord. 60 days is statutory period.
Nothing more than the articles have been seized.
Yes.
According to the event of custodial intervention on we further find that the petitioner is incarcerated for a period of 45 days.
But 58 days.
58 days. Though the charge sheet has not been submitted, but the articles have been seized. And therefore, we do not find that the further custody of the petitioner is necessary. Accordingly, released on bail, satisfaction of severe.
But ACGM Mekliganj, my lord. Additional Chief Judicial Magistrate Mekliganj, Kuch Bihar.
The condition that he will attend the case. Now, he will meet the investigating officer once in a week. Because the investigation is going on.
Yes, my lord.
We are coming back, don't worry. Huh? 5,000
My lord, may I submit one thing?
My lord, one matter is still we are.
My lord, instead of local surety, my lord, 5,000 can be my lord registered surety, both 5.
Because once
The judgment of
Now the entire list is exhausted.
Lordship, in item number 15, Lordship, this is the joint case. My lord, excuse me, I could bring only one copy, and for your lordship's convenience, I have marked the relevant code.
Page. अच्छा, पैरा. Yes.
Now, I just wondered who will be the sanctioning authority?
DM, Lordship.
Where is that?
Lordship, if my lord is kind enough to take section 39 of the Arms Act, it reads, my lord, no prosecution shall be instituted against any person in respect of,
Just, that is what we want.
and so also says the Explosive Substances Act. My lord,
Previous sanction of the district magistrate necessary.
in certain cases.
It says the previous permission
Lordship,
under section 3.
Lordship.
And
And my lord, section 7 of the Explosive Substances Act, which also says without the permission of the DM. No court shall proceed to the trial of any person for an offence against this act, except with the consent of the district magistrate.
section
7, lordships.
no, 7 of the explosive act.
Lordship, 1908.
Yes. No, explosive act of
Explosive Substances Act of 1980.
সাবস্টেন্স একটা নেই এখানে না, এখানে আমি দেখলাম এটা, সেই জন্য এইটা আছে পেজ 295.
So, my lord, even prior to the filing of the submission of the charge sheet, the agency had written to the district magistrate to accord sanction. That was on 13/6/2022. And the last letter that we have been writing to them is on 16/1/2024. But no sanction is forthcoming.
Consider your application. A frequent situation has arisen in the instant case. And the counsel for the CBI submits before us that although the investigation is complete in all respect, and the draft charge sheet has already been prepared, yet the sanction from the district magistrate has not been obtained, despite several requests being made since the year 2022. Initially, the case was registered under the Explosive Substances Act 1908 and the Arms Act 1959 by the state police. But later on, the entire investigation was vested upon the CBI in terms of the order passed by the the 5-judge bench of the High Court. The petitioner seeks parity on the score that similarly circumstanced persons were granted bail. But we find that those orders were passed before the entire investigation was entrusted upon the CBI. And even some of the co-accused have been allowed bail subsequent to that. We will consider the case on merit, more particularly whether the petitioner stands on the same footing that of the others who have been granted bail. But we cannot shut our eyes to an impasse having created in not according sanction required under Section 7 of the Explosive Substance Act 1908 and Section 39 of the Arms Act by the district magistrate. Since the offences are registered under the aforesaid acts, and the investigation is undertaken by the CBI.
Lordship, there is also 302. Lot other sections are there, 149, 147, 302.
Aforesaid act, along with Section 302 of the Indian Penal Code.
302, 147, 148, 149, 302, 307 of items. And 34.
How are we trained for? If the offense registered. No, since the FIR is lost. So, under Section 302.
307, 147, 148, 149, read with 34.
No, Explosive Substance Act
And Arms Act.
Then are the specific sections of those. Is registered under section.
25 and 27.
And is under Section 147/148/149/302/307 of the Indian Penal Code, together with Section 3 of Explosive Substances Act 1908, read with Section 34 of the IPC, and under Section 3, within bracket 1, within bracket another one,
Lordship.
1/3 within bracket 2 within bracket small Roman V. 5. And within bracket small VA of SCST within bracket POA Act 1989. There is no Arms Act,
Lordship, there is, my lord, that is section 25, 27, and 3 and 4.
but that is, it was registered under that. Later on. we
Later
have
on it
added.
was given. Later.
But later on, after investigation, the offenses under the Arms Act 1959 was also included. Come on. By virtue of the provisions contained in the aforesaid acts, the sanction of the district magistrate is mandatory. It is really alarming that after completion of the investigation, a draft copy of the charge sheet was sent.
Entire.
A draft copy of the charge sheet,
We have filed a final charge sheet. Only the charges could not be framed. my lord.
draft copy of the charge sheet. For sanction, it is required. It's a draft copy. Like a copy of the draft, copy of the charge sheet, along with all necessary papers, were forwarded to the district magistrate Jalpaiguri,
Kuch bhi, lordship.
sorry, Kuch Bihar, Vide. Letter dated 4/10/2023. And the reminders were,
My lord, first was written 9/9/2022. Even
I
before,
find from your letter of,
lordship.
it was forwarded on 13/9/2022. 13/9. Beta 4/10 bolechi, beta 13/9/2022.
And the reminders were.
Were also given on 4/10/2021, 6/11/2023, 20/11/2023, and lastly on 16/1/2024. We have perused the provisions contained under section 39 of the Arms Act, which provides that no prosecution shall be instituted against any person in respect of any offense under section 3 without the previous sanction of the district magistrate. However, section 7 of the Explosive Substances Act 1908 further postulates a consent of the district magistrate before the trial of any person for an offense under the aforesaid act is proceeded with by the court. There appears to be a complete fetter on the part of the investigating agencies in proceeding with the case unless the sanction or the consent of the district magistrate of the concerned district magistrate of the district is obtained. It is a sordid state of affair that nearly 1.5 years has elapsed. Yet, the sanction or the consent has not been given by the district magistrate, who is sitting over the file. And giving encouragement to the accused in approaching the court for his release on bail, as The trial has not been completed. Obviously, because of the fact that the charge sheet has not been filed. Since the aforesaid provisions does not contain any time limit within which the sanction or the consent is required to be given by the district magistrate. Come on. In an identical situation, the Constitution Bench of the Supreme Court in case of Vinit Narayan and others versus Union of India and another, reported in 1998, volume 1, SSC 26, was considering a case relating to prevention of Corruption Act 1947. The identical provision is contained in the said act, and there appears to be apathetic attitude shown by the competent authority in not granting the sanction within the reasonable time. The apex court was of the view that since there is no similarity between a mere executive order requiring prior permission or sanction for investigation of an offense and the sanction needed under the statute for prosecution, and therefore the sanction of prosecution, if provided under the statute, is prerequisite for the court to take the cognizance of an offense. The apex court was also considering a case where there is a complete silence of any statutory requirement of prior permission or sanction. And thereafter, bearing in mind that the delay should not be unnecessarily dragged, passed an order that in every such case where the sanction is required under the statute, the time limit of 3 months for sanction for prosecution should be strictly adhered to. By virtue of Article 141 of the Constitution of India, the law declared by the Supreme Court is binding upon all the courts, including the authorities who cannot act contrary thereto. As indicated above, more than 1.5 years have passed. Yet, the sanction or the consent has not been accorded by the district magistrate, Kuch Bihar, which is apparently in conflict with and or in violation of the mandate given in Vineet Narayan Supra by the Supreme Court of India. We therefore direct the district magistrate Kuch Bihar to submit a report before us as to why such time limit set forth in the said judgment rendered by the Supreme Court in Vineet Narayan Supra has not been adhered to. Such report shall be filed within 10 days from date. However, it is open to the said district magistrate to take an appropriate decisions in the meantime. Irrespective of the fact that this court has directed the report to be filed before the time within the time limited hereinafter. The case for the purpose of bail can be considered after such report is filed by the district magistrate Kuch Bihar.
Grateful, my
But
lord.
only one indulgence, my lord. But your lordship has recorded, my lord, that the co-accused have been granted bail by the learned court below, my lord, before the Central Bureau of Investigation, my lord, entrusted the investigation. My lord,
No,
that,
no, I have said both, subsequent, then you interrupted me, even subsequent there.
my lord, they have been granted bail after they have, my lord,
Even
entrusted the
subsequent
Said
date.
both.
lordship.
The honorable court has recorded that. Grateful.
About 16.
One is a password. Because 16, who is appear?
I myself.
What is this matter?
This is regarding that explanation was called for from the additional.
Yes, where is that explanation?
To the register.
Always after brief.
Yes. Yes. What do you say?
My lord,
Tell me.
there is a violation in 52A. The sample you have sent,
We are concerned with you said that despite the direction twice, that has not been completed.
thrice.
Right.
And there is a direction, not only within when within 3 months is not completed, then I can renew my bill fare.
True. But it appears that, yes, why?
Our 3 personers,
How many is there? Why can't you produce the other? Why you are thinking about the magistrate to give an evidence? Other witness? Other witness?
after passing the order, my lord, 4 time is no.
Who are the other witnesses? 10 has been examined.
No. 8 are examined.
No, 10. One has been, he is discharged. Now the number has come down to 12. One has been discharged. Yes, sir.
At the
Ten
certified
is
copy.
the judicial magistrate lordship.
No, I know that he has highlighted. What about the other rest?
Pasang Topgi Bhutia. ACP, it must be in Shiliguri. RO and I. RO
So
is
17/4 is the date fixed for that. Produce those, if the judicial magistrate cannot appear on that day. Produce them, give an evidence. We are saying that on each day, this matter has to be fixed. Every day you'll have to examine the full of it.
lordship.
From 17.
We understood.
52A trial. Take that.
No, my lord, it is a mandate, the equal protection of the equality of law.
Judgment
Ah.
that 52A
No.
offense.
But three person is enjoying the bail. It is mandate of constitution, the equality of law, equal protection of law.
No,
They are enjoying, my lord.
Very
And put that-
recent judgment of the Supreme Court, have you seen? The Supreme Court says that we are saying the parity will not do. We'll have to indicate what are the parity.
And other thing is that, my lord, the eight witness is already done.
It has 10 witnesses there, 9 has been discharged.
And there is no chances for conviction. The witness till now.
232.
My lord.
232, make an application before the special court saying that the witnesses have not proved anything. Let me acquit.
And we have filed a petition, 58 of the NDPS Act, filing an affidavit. There's a false implication and vexatious search and seizure, my lord.
Take that plea of at the time. Pursuant to our order. Last country. The additional district and session judge. Come, the special judge within the NDPS Act. Submitted the report video. The report vividly narrated the incident happened on each day when the matter is listed. And the progress shown there. It is no doubt true that on several occasions this court showed its angus in delayed disposal of the case. And in fact, it requested the learned judge of the special court to bring the case to its logical end within a time frame, within a time limit set for there. We have seen the report wherefrom it appears that at least 3 dates have been lost because the judicial magistrate who is cited as a witness could not make herself available for the reasons disclosed therein. The next date is fixed on 17/4/2023. Though the learned judge have highlighted the number of cases pending in his court and his endeavor to take up all such cases by fixing the date in a close proximity of time. Come on. We need to, we venture to make a comment that the pendency of the cases to a considerable number is imminent and evident in every courts in the judicial system. The moment the court, the higher court has requested that the matter should be disposed of within a time frame, at least some promptitude should be shown. By the judicial officer treating such requests so that the request so made is not rendered farcical and or redundant. If the time limit of 3 months was fixed, we are unable to comprehend ourselves. We are unable to comprehend the stand of the judicial officer that the matter is fixed every month. Be that as it may, we do not intend to summarize the judicial officer, nor intend to make any comment or to make any adverse remark. Adverse remark, as he is not present before us. But we expect that the utmost respect to the request made by the High Court should not only be done, but seem to be done. The next date is fixed on 17/4/2023 for the evidence of the magistrate. We therefore direct the special judge, NDPS court, to take up the matter on the same date. It is submitted. Now, we are conscious of the fact, as discerned from the said report, with regard to the absence of the judicial magistrate, and on being asked, the learned advocate appearing for the state submits that in the event the said magistrate could not secure her presence for giving evidence, comma, the prosecution shall bring the other witnesses for their examination. Full stop. In the event the evidence of the left out witnesses have not, are not complete on 17/4/2023, the learned judge would fix the matter on day-to-day basis, so that the evidence of the witnesses are recorded in its entirety, and shall thereafter proceed to dispose of the matter within 1 month therefrom. Since the earlier applications for bail filed by the petitioners were dismissed, we do not find that the moment the trial has reached at the advanced stage, there is any, that the petitioner has make out a case for enlargement of bail. Accordingly, the player for bail is rejected.
Liberty, my lord, if it's not completed, then.
No, but yes. This is, every time the request was made, this time the direction is.
And after that, given a liberty to come before your honor, my lord.
Let this order be communicated to the concerned judge by the registrar of the circuit bench at Jalpaiguri immediately.
Can I renew my bail pair after that, my lord?
That's your right, sir. That's your right.
Anytime, but there was the order.
There is no difficulty, sir. Yes. Yes, which matter?
My lord, I am praying for my lord expeditious trial, my lord. In this case, total 19 witnesses there, my lord. Only one witness has been examined for last 1 year.
March for recording of evidence of.
But only,
How long it will go?
but
Which court? Siliguri or what?
Shiliguri, my lord, Shiliguri.
He has said that the 59 cases, there is a direction what can be done. So,
But kindly give me 1 year, my lord, kindly give the direction for 1 year. Within 1 year, my lord, the trial will complete. And unless, my lord, if one witness has taken time and has been examined for one.
we will simply say, we are not putting any pressure on him because we have seen the report. What we say is mandating them to produce the witnesses on each day when the matter is fixed.
But kindly.
And in the event any of the witnesses could not come, then at least there must be more than one witnesses so that the examination is not hampered.
But difficulty is that, my lord, last witness has been examined on the month of October. And next is next date was fixed on month of March, my lord. But the gap is very long, my lord.
Sir, after all, everybody is a human being.
Yes, my lord,
They
I
have
will appreciate, my lord.
limited potential, they have a limited.
And if, my lord, if that is the, my lord, speed, my lord, it will take 19 years for 19 witnesses, my lord.
It will not, definitely.
And kindly consider this aspect also.
This is the third application for bail at the behest of the petitioner. The earlier two applications.
Lastly rejected on 6th of June, my lord.
the
There is
earlier
no
two
problem.
applications were rejected at the court did not find any ground to take an exception to section 37 of the NDPS. The contraband above the commercial quantity is allegedly recovered from the petitioner. The counsel for the petitioner submits that the trial has been unnecessarily delayed as only two witnesses or one witness, one witness has been examined
Out of 19.
out of 19. Our attention is drawn to the fact that the next date for recording the evidence of the second witness is fixed on first March 2024. The prosecution is directed to produce the witness on the said date. And even the said witness could not be produced, the prosecution shall ensure that the next witness is brought to the court on the same date, so that the trial may not so that the trial may not be impeded. The Council for the State assures this court that on each day fixed for recording the evidence of the witness, the witnesses shall be produced, and there will be a complete cooperation from the prosecution in this regard. The counsel for the petitioner also assured that in the event the examination in chief of the witness is recorded by the court, the cross-examination shall be done. And neither and we have a need. Both the counsel says that they would not indulge in unnecessary adjournments in the matter, and shall cooperate the special judge in completing the trial within a short span of time. No. Since we do not find any change circumstances in the interregnum between the last rejection and the filing of the instant application, the instant application for bail is rejected. However, we expect that the special judge NDPS court will make endeavor to bring the case to its logical end as expeditiously as possible.
But may I submit one thing? But I am behind the bar more than 1.5 years, but behind the bar without trial, but only one witness, man. Kindly framing the bar.
No, we have said, don't, we have said. Yes.
That is also the more change circumstance.
Come back
But
before rising, one mentioning, day before, regarding day before yesterday, there was an order passed regarding that matter, regarding sending the Wakalatnama and the check for the handwriting expert. The IO is present. Problem is the original Wakalatnama is required for sending it to the handwriting expert.
What Wakalatnama? Wakalatnama is not required.
My lord, as per the Wakalatnama which is lying in this court in connection to CRM number 659, which they have challenged, that Wakalatnama, it is not our signature, to send it, the original Wakalatnama is required.
Why can't be done by any other?
Any the photocopies are there.
In High Court also, the handwriting expert comes and takes a capture or a capture. They do not say, they capture. And then they go.
Then we'll talk with the registrar.
No difficulty. That is what is the procedure here in the High Court. The record is never sent to the handwriting expert.
Just record the Wakalatnama.
Yes, they come, they take a picture, they capture the picture, and then they do it. They never took any document from the High Court.
Sorry for the inconvenience.
In original side, there are a lot of suits which are tried, handwriting experts are appointed. Documents are never taken there.
Yes.
They capture with with the camera, and then they are coming at 2.
This is my application.
Actually, I'm not pressing the application, Lordship.
Not this.
Not of this, Lordship.
Not pressing. Three applications were there. Who is the? Where is Mr. Anirban Banerjee? He mentioned the matter for non-prosecution. Non-prosecution.
I appear to be university, Your Lordship.
Three non-prosecution. Already served the February period, charge sheet not served.
This is my application, my lord. My lord, we have effected service. But that we mentioned it today, my lord, we have served it, and my lord, this is the affidavit of service. And my lord, the affidavit in reply, my lord, to the opposition. My lord,
There was an earlier direction to file affidavit in opposition, my lord.
what state?
Yes.
Can I have a?
Yes, sure.
What about the service on the other respondent, your wife?
My lord, I am the wife.
Because you are a wife,
My-
is your husband.
My lord, we have served, my lord.
Where is that?
By hand service, my lord, to their,
Who is your husband?
my lord, and they are appearing. Mr. Devorshi Dhar is representing them. Respondent number 5 is the husband, 6 is the father-in-law, and 7 is the mother-in-law.
Yes.
Now, my lord,
Where is the boy?
Yes, I am led by Mr. Probal Mukherjee, Lordship.
Hey, এটা কি into লাইভ স্ট্রিমটা করেছো তো জাস্ট আওয়াজ যাবে না তো না 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 উনি তো অ্যাপিয়ার করছেন ওটা তো ওনাকে উনি ছাড়া বাকি গুলোকে তুমি ওটা দেখে দাও is relating to child, it should not be live stream.
my lord,
Lordship. Lordship.
my lord.
Somaya is not required. Come. এই আর কি আছে দেখো notification of 2004. This agenda, এখানে যেটা আছে, this is a major where this 27 12 section says, agreement Sahara signature has been ratified for the meeting of the it is suspension এর ক্ষেত্রে হয়েছিল, but এটা করেছে. So this has been done. যে জায়গাটা একটা প্রবলেম হচ্ছে যেটা আমি দেখছিলাম এখানে বলছে যে নোটিফিকেশন was issued in the section 5 And it says the power conferred upon Congress, as it is not an application under section 2(6), the question of executive does not arise. কিন্তু এখানে যেহেতু ওটা অ্যাপ্রুভ করলো যে কি প্রসিড, তার মানে হচ্ছে কোনো ব্যাপারই নেই। সেটাই বলছে, ওটাই বলছে যে নোটিফিকেশন। দাও এই দেখো, the scope of the instant appeal which was within the limited contour have been expended by the eloquence of the counsel for the appellant, inviting the attention of the bench to various provisions of the acts and the acts, rules and the ordinance, in order to buttress the contention that the charge sheet issued by the Vice Chancellor is bad, illegal, and without jurisdiction. A prelude to the litigation can be seen from the fact that the university decided to initiate a disciplinary proceeding against the appellant, alleging misconduct, and a show cause notice was issued by the Vice Chancellor, which is assailed by the appellant petitioner before this court. The single bench dismissed the writ petition, dismissed the contention of the petitioner that the charge sheet suffers from serious infirmities and or illegalities, but kept all the points which was agitated by the appellant open for the decision of the inquiry officer, and further liberty was granted to the appellant to challenge the entire disciplinary proceeding at the appropriate stage, including challenging the charge sheet on the same grounds which have been urged in the instant writ petition. According to the learned advocate for the appellant, the university, according to the learned advocate for the appellant, the show cause notice issued by the Vice Chancellor is infirm, bad, and illegal in view of the provisions contained under Uttar Bango Krishi Vishwavidyalaya Act 2000. In order to further the aforesaid submission, the reliance is placed upon clause L of subsection 1 of section 11 of the said Act, which gives power to the Executive Council to approve the recommendations for appointment of the officers, teachers, and the non-teaching staff in the manner so prescribed. Taking clue therefrom, it is sought to be contended that the moment the appointing authority is the Executive Council, the Vice Chancellor is denuded of power to issue a show cause notice or initiate a proceeding thereupon. For the simple reasons that he being not the Executive Council cannot usurp such power in absence of any statutory provisions. Mr. Mishra, the learned advocate for the appellant, further relies upon the provisions contained under section 26 of the said Act, which confers the power upon the Vice Chancellor to take any action in emergency, which in his opinions calls for immediate action. But such action is required to be approved by such authority or the body which would further be evident from subsection 7 of section 26 thereof, where the Vice Chancellor shall only give effect to the orders of the Executive Councils regarding appointment, suspension and dismissal of the officers, teachers, and other employees of the university. Stop. According to Mr. Mishra, the conjoint reading of the aforesaid subsections leaves no ambiguity that the Executive Council, being the appointing authority, is regarded as a disciplinary authority, and any actions initiated in contemplation of the disciplinary proceeding can only originate from the Executive Councils. And even if the Vice Chancellor exercises such emergency power, all such actions are required to be ratified and approved by the Executive Council. In this regard, it is submitted that since there is no approval or the ratification and or waiting by the Executive Council, the entire action is per se illegal. According to Mr. Mr. Mishra, the other provisions contained in section 35 and 40 can also be, no, sorry, can also, also corroborates the stand that the Executive Council is an appointing authority, and the terms and conditions of the service in relation to the teacher has to be prescribed by the said council, and therefore the Vice Chancellor cannot usurp such power by referring section 51 of the said act. Mr. Mishra submits that the power to make first statute is vested upon the state government, and in exercise of such power, the first statute was enacted on 30th April. First statute was enacted on 30th April 2001. Stop. It is no, Mr. Mishra refers to section 2 within bracket clause B of the first statute, defining the appointing authority as the Executive Council of the university, and thus the Vice Chancellor cannot act as a appointing authority. As per Mr. Mishra, even section 80 makes the position more clear that all teachers on their first appointment under the university shall be provided with a letter of appointment by the Vice Chancellor by putting his signature, which does not take away, which leads to an inescapable conclusion that the Vice Chancellor merely acts as a signing authority and the Executive Council as the appointing authority. Mr. Mishra relies upon several provisions of the Bidhan Chandra Krishi Vidyalaya Act 1974 in support of the aforesaid contention. More particularly, section 39 thereof, conferring a power to make the ordinance or the first statute and in pursuance thereof an ordinance was promulgated known as an ordinance relating to discipline, penalty and appeal in respect of employees of Bidhan Chandra Krishi Vishwavidyalaya. Ordinance. No, sorry, ordinance was key or was promulgated. কি বলেছি? No, ordinance known as Bidhan Chandra Krishi Vishwavidyalaya within bracket discipline, penalty and appeal, bracket close ordinance. According to him, the definition of an appointing authority and the disciplinary authority means the authority empowered to make appointment to the post and an authority competent to impose on him that penalty. He relies upon the Schedule 1 appended thereto, wherein the appointing authority is shown as the Vice Chancellor with the approval of the Executive Council, and the authority empowered to impose penalty is also shown as Vice Chancellor. देखो Mr. Misro further submits that the said ordinance was adopted with a notification dated 27/12/2004 but in case of an initiation of a proceeding, there is no document forthcoming which permits that in case of they said ordinance is made applicable to the petitioner. In other words, it is sought to be contended that there is no ratification and or waiting and or approval from the Executive Council. And in such view of the matter, any action contemplated under the said ordinance is infirm, faulty, and therefore required to be nipped in the bud. On the other hand, the state submits that in the meeting of 70 in the 74th meeting of the Executive Council, the approval was given by the Executive Council and therefore it cannot be said that the Executive Council has not taken any action. It is further submitted that all the paraphernalias required under the said ordinance have been followed, and therefore there is no illegality in or infirmity in the order of the trial court. In reply, Mr. Mishra submits that the aforesaid 74th meeting of the Executive Council was in relation to a revocation of suspension and therefore cannot be construed as an approval or waiting in relation to an ordinance. On the conspectus of the aforesaid stands taken by the respective parties, the seminal point involved in the instant appeal is whether the charge sheet issued taking a clue from an ordinance is liable to be quashed in absence of the powers have been conferred upon the Vice Chancellor. At the very outset, we must record that the scope of judicial review in a case relating to a challenge being thrown to a charge sheet at the threshold is very limited. As the authorities contemplating a proceeding have not arrived at the final decisions. The charge sheet or the show cause notice can be impinged if the authority issuing the same inherently lacks power and or jurisdiction, or have not been conferred such powers, or such power is conferred upon other authority, or on a bare look of the articles of charges, it is difficult to understand the meaning thereof on the ground of vagueness and not the least issued under the wrong statute. So far as the vagueness point is concerned, we do not intend to dilate much thereupon after looking at the articles of charges. Nor we find any infirmity at this stage, and therefore do not intend to make any comment thereupon. For the simple reason that the trial court has kept all points open, and if agitated at an appropriate stage, shall be decided by the competent authority. No, oh, it does. Admittedly, the Uttarbanga Krishi Vishwavidyalaya Act 2000 applies to the present university, which appears to be a complete and exhaustive act in relation to its functioning and the other allied matters. But there is a conscious omission of any of provisions relating to a disciplinary action to be taken against the employee or the teachers of the said university. Section 10, subsection 1 of the said Act vividly reflect the constituents of the said Executive Council, and the Vice Chancellor is imbibed within the ex officio members. The powers and the powers, functions, and the duties of the Executive Council is extensively incorporated in Section 11 of the said Act, and the Clause L of subsection 1 of Section 11 gives clear indications relating to the approval, regarding the power to approve the recommendation for appointment of the teachers, officers, and non-teaching staff. The said provision, if read conjointly with Section 35 of the said Act, it leaves no ambiguity that the teacher or the professor or the reader of the university shall be appointed by the Executive Council on the recommendation of the selection committee. Containing the terms and conditions of such an appointment as may be prescribed by the said council. By virtue of the section 51 bestowed power to make a first statutes in relation to the matters set forth in subsection 1 to 10 of section 50. And it would be evident from subsection 3 of section 50 that the manner of appointment and the terms and conditions of the service of the teachers of the university is engulfed therein. The first statute, as indicated above, was promulgated on 30th April 2001, which also indicates the Executive Council as the appointing authority. To this regard, we do not find any ambiguity and or a dissent. Even section 80 of the said first statute provides that the teachers who are appointed for the first time in the university shall be provided with the letter of appointment under section 40 of the Parent Act, and to be signed by the Vice Chancellor. We would not have ventured further on a assimilation of the aforesaid provisions and arriving at the conclusion that the Executive Council is the appointing authority and the Vice Chancellor is a signatory to the letter of appointment issued to each teachers appointed in the said university. We cannot overlook the fact that there is no provision relating to a disciplinary action to be taken against the employees, officers, and the teachers of the said university. Semicolon. Even the first statute does not contain such provisions. Full stop. The genesis of the Act of 74 can be traced that prior date, the genesis of Act 2000 can be traced that prior to its enactment, Bidhan Chandra Krishi Vishwavidyalaya Act 1974 was in vogue. Containing an exhaustive provisions relating to the establishment of the universities and its functioning, as well as the powers conferred upon the various authorities in this regard. Both the acts contained the powers to make the first statute and also the ordinance. Which would which is fortified from section 39 capital A of the Act of 1974, and on the meaningful reading of the provisions contained under section 50 and 51 of the Act of 2000. Since an ordinance was promulgated in terms of promulgated under 1974 Act, comprehensively in relation to a discipline, penalty and appeal of the employees, including the teachers, there was no separate ordinance promulgated in exercise of the powers under the Act of 2000. The university felt that in absence of any comprehensive legislation, the administration of the university was not in a proper shape, nor any action could be taken against its officers, employees, and the teachers, the ordinance, the aforesaid ordinance was adopted by a video notification dated 27/12/2004. A plea sought to be taken that the said notification is signed by the Vice Chancellor and has not been ratified by the Executive Council. It cannot be applied, nor any action can be taken thereunder. We notice from the said notification that the Vice Chancellor, in exercise of the relevant powers conferred under Section 26 of the Act of 2000, adopted and enforced the said ordinance with immediate effect. The reference is made to another communication indicating that the said notification is issued in exercise of power under Section 27(6) and not under 26(6), and therefore the question of approval of the Executive Council does not arise. But we find from the documents produced before us in the instant appeal, more particularly the extract of the 74th meeting of the Executive Council, though relatable to the revocation of the suspension, but clearly indicates the action taken against the appellant under the aforesaid provisions of the ordinance, which would further be seen that one of the contentions raised in the said meeting relates to an approval of the Executive Council for taking actions under the provision of the ordinance, and ultimately the said resolution was approved. The ordinance indicates the action to be taken by the Vice Chancellor, and as a discipline, as an authority empowered to impose penalty, We thus do not find that the charge sheet issued by the Vice Chancellor is liable to be impeached at this stage. Full stop. Furthermore, there is no challenge thrown in the recent writ petition on the adoption of an ordinance under the said notification, nor the competence of the Vice Chancellor in this regard, nor the ordinance being in conflict with the Act of 2000. We do not intend to go into the aforesaid aspect. Since we find that there is no infirmity in issuing the charge sheet by the Vice Chancellor at this stage, we therefore decline to make any interference with the impugned order. The appeal is thus dismissed. All connected applications filed therein are accordingly dismissed.
We have filed a vacating application. Kindly allow that. Can 2 has to be allowed, and kindly vacate the interim order of 30th of November.
Interim order is passed by the court in aid of the final relief. If the final relief is a dismissal of the proceeding.
Yes. Your Lordship, will you please to record that Your Lordship is dismissing the applications filed in connection with the appeal.
I have already said so that the appeal is dismissed. All connected applications are also dismissed.
As Your Lordship pleases.
At this stage, my lords, may I request there to be a stay upon my lordship judgment so that we can approach the Supreme Court. Lordship.
Sure.
Let there be a stay.
I'm opposing the prayer for
After hearing the counsel for the appellant, who prays for stay of the operation of the impugned judgment.
But I am opposing the prayer.
We do not find any ground in this regard, and therefore such prayer is refused.
Grateful.
Urgent photostat certified copy, if applied, be given within 3 days from the date of the application.
Grateful to Your Lordship.
Yes, thank you.
বলে দিচ্ছি